Good evening, everyone. My name is Eric Bulwith. I am the rent leveling administrator for the board meeting tonight. Today is the third day of October in the year 2024. This meeting of the Jersey City Rent Leveling Board, which was scheduled for 6 p.m. It is now 6:09, and I will conduct a roll call for the commencement of this meeting. Alexander Hamilton,
Here.
Michael Brown, Danon Hill,
Here.
Sullivan Johnson,
Here.
James Eacock,
Here.
Elda Pinchinot.
Here.
Okay, we have all board members present with the exception of one. We have a quorum. On behalf of the Rent Leveling Board Chair Danon Hill and Board Commissioners, in accordance with the New Jersey Public Laws of 1975, Chapter 231, the Open Public Meetings Act, also known as the Sunshine Law, adequate notice of this meeting has been provided by the posting on the bulletin board of the first floor of City Hall in the form of a schedule of city meetings and caucuses for the calendar year of 2024, as well as a filing of that schedule with the office of the city clerk. Yeah, we had the special meeting. Sorry, this is. I should add that this is a special meeting. The agenda was similarly disseminated on Tuesday, September 24th, 2024, with the Jersey Journal, and posted on the Office of Landlord-Tenant Relations webpage that same day. So I can certify as to the total compliance with the Sunshine Law. There are 2 cases on the agenda tonight, and we also have, but like a third matter, which is swearing in a new hearing officer, Lendy Salazar.
Let's do that first.
Okay. Tonight, I just asked when you come up to speak, for everyone that is, just make sure that the microphone is on and you're speaking into the microphone.
First.
I'm sorry?
You want to do the swearing in first, and then
Yeah, we can do that.
Yeah.
Yes, of course. So we'll swear in the hearing officer. Lendy, if you could just go up. Do you have the oath? Yeah. Or do you want to?
go to the
Swearing?
microphone. Go to the microphone. Go to the microphone.
Just as long as you into the mic. Yeah. For the
No, that mic right there. Okay.
I,
State your name.
Lendy Salazar,
Do solemnly swear
do solemnly swear
or affirm that I will faithfully,
or affirm that I will faithfully,
impartially,
impartially,
and justly
and justly
perform all the duties
perform all the duties
of the Bureau of the Rent Leveling
of the Bureau of the Rent Leveling
according to the City
according to the City
of Jersey City
of Jersey City
Rent Control Ordinance,
Rent Control Ordinance,
Chapter 260,
Chapter 260,
to the best of my ability.
to the best of my ability.
So help me God.
So help me God.
Congratulations.
She's not okay. President. She's not okay.
Motion. Do we have to do a motion, right, to accept her? Or no? No?
No, you just have to swear her in. So the 2 items on the agenda tonight, the first one is a vacancy capital improvement appeal for the property 79 Randolph Avenue.
Okay.
And
So,
board chair, I defer to you.
yep. All right. 79 Randolph, Mr. Dimitri Galestos? Yes. Am I saying it correctly?
Chair, if you could just please make sure you're speaking into the microphone.
Sorry about that.
Thank you.
Okay. Okay, this is claim number VCI 2023-0064 for 79 Randolph Avenue for vacancy capital improvement appeal.
Yes.
Mr. Glenn. All right.
So Dimitri Galetso. Goletsos.
You swear the testimony proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay. You want to? Floor is yours.
Well, so basically, I had a renovation done, and within the renovation, there was a bathroom that was renovated, and the breakdown on the bathroom came out to 13,000 and change from my contractor. And the inspector came in and said it should have only been, I believe, $6,000 or $7,000 for the renovation. It was a $7,000 deduction. Based on average bathroom renovations within the internet, 16.5 for a regular bathroom renovation. So mine was well below the amount of 16.5. And I have two estimates from two different contractors, one at 17.8 and the other one at 15.5 for the exact same bathroom renovation within the same building. So that's pretty much my case. I feel 13,000 is way below what contractors charge for bathrooms, from what I've been told from numerous contractors.
Okay. Any commissioners have any questions?
Well, actually, my questions are not going to be posed to you, sir. I actually wanted to see if we'd have an opportunity to speak to the inspector as well, so that we can have a better understanding of his fees and the position that he was taking.
I have one question.
Oh,
You just mentioned estimates. Were the estimates included? I don't know if we had them in our package.
I submitted. No, I got the estimates after I was appealing it. I didn't know I had to get to.
Oh, okay. No, because
But
we
I
didn't see
submitted
them.
the within the state of New Jersey, where it says the minimum average bathroom is $16.5 up to $40,000, pretty much.
Yeah, it's a
I
wide
believe-
range.
I believe that was submitted.
Oh, yeah, something was submitted that said 6,500 to 25,500, which is an unworkable range for us to look at.
No, I think that I don't believe that's what was submitted. I believe
Oh, then there's can range from 16.5 to 69.5.
16,000 and up is the one low-end bathroom renovation, it says here. Low-end bathroom renovation, that was one off the internet. Second one says, for an average full rip and replace bathroom remodel in New Jersey will range from 16.5 to 69.5.
Yeah, that's a huge range, so that's why we have to.
But I'm at 13, so I'm getting below
Yeah.
what the 16 is. And then the two estimates I got from two separate contractors within New Jersey, one, for the same exact bathroom, because it's within the same building. The one gentleman gave me an estimate of 17.5, and then the second one gave me an estimate of 15.5. It's still above what the original contractor charged me to do the renovation. Pretty much, they said if the inspector can do it for 9,000, he'll have a bunch of jobs for him to do at that price.
So, if I could just interject for 1 minute. So what he is referencing was not part of the file and was not submitted to the Bureau into evidence. There is a time frame. You have to provide that to the tenants that are there and to the Bureau 10 days in advance before the hearing so that we can provide that to you. So I just wanted to make the record clear that he is referencing items that were not part of the application.
No, that was part. She told me it was submitted. Not the two estimates from the separate contractors, but the other stuff from the internet were not submitted.
The two estimates were,
Please raise your right hand. You swear the testimony about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thanks, Tom.
The two estimates were not submitted
Yeah.
for evidence for this.
But what was submitted was the reference from the state, where it referenced from 16,005 to 69,005. That was submitted to show that that's what an average bathroom costs. I just got the two estimates from two separate contractors. I didn't know I had to submit that, the other two estimates.
Okay.
But I did submit the other stuff from the state off of Google, what the average bathroom costs to renovate.
Okay. You want to speak to the hearing officer?
Well, in the submission. See, yeah, in the submission, yeah. Well, yeah, actually, that was going to be one of, what we're here to do is try to see if we can come up with something that's fair.
Okay.
And to a point, if you have some documentation that's yet to be submitted because it wasn't submitted within the appropriate time frame, you know, one of my suggestions is perhaps maybe you want to go and resubmit that for an additional review.
Okay.
Because as it stands right now, we have to base our decisions on what we're looking at. And if we have documentation that is not included in our package, then, you know, we're hard pressed to really give that
It's
consideration.
understandable.
So,
Tom?
So the original deduction that the inspector had done, it wasn't me, it was one of the other inspectors, was he deducted, he allowed $6,807, and he deducted $6,700, which basically, you know, he's saying the bathroom should have only cost $6,800. To me, that is a very low number. The gentleman didn't provide secondary estimates, but if I was going out and doing it, I would have granted at least a $10,000 allotment for the bathroom. And the only reason it wouldn't have been higher and closer to his original amount is that he didn't replace the bathtub. All he did is reglaze the bathtub. To be fair to the tenants and the owner, I would recommend that we allow $10,000 for his bathroom. To me, that's fair and reasonable for a bathroom renovation. To me, again, it only wasn't a total renovation because he didn't replace the bathtub. If the board's agreeable to that, rather than to keep postponing it and to let him come back and provide that documentation, again, that's up to you, gentlemen and ladies. But if it was me, I would have granted a $10,000 allotment for the bathroom. I don't know if the owner is acceptable or agreeable to that, and try to, you know, resolve this and just finish it.
I mean, that's
It's basically splitting it in half.
Right.
From what the inspector said to what the estimates that the owner got and what he claimed he paid for it. You know, actually, his estimates were much higher.
right. But
Yes, then replacing them, well, that's why I said it wasn't a complete bathroom renovation. Otherwise, I wouldn't say it was worth 10,000, it would have been worth more like 12, 13,
right.
maybe a little higher, but to me, that's the difference between a full gut renovation and a renovation.
Anybody else?
What would be the sorry, go ahead. What would be the differential in terms of like the rent increase from the 10,000 to the 6,000?
Geez, I have to, I have to whip out the calculator and.
So, sorry.
I should
Again-
say, so if there is an adjustment, and there is a tenant now present in this unit, whatever adjustment is made will not be applied to that tenant, it will be applied to the base rent of the unit. Just because now the tenant going, you know, has a lease and has agreed to a rent, so that rent cannot be increased with
Right.
with a surcharge. It can only be increased with a cost of living increase.
But then my question is
but
irrelevant. Yeah.
if there is a change to the increase, it will be applied to the base rent. If there is a tenant present in this unit
Yes.
now?
He's leaving actually this month. He's going back to Brooklyn.
Okay, so. Okay, then. Well, then it would be applied to the base rent. Now that tenant leaves. Once that tenant leaves, then you can apply the increase.
Well, it would actually be a decrease.
I'm sorry, decrease. I'm
Yes.
sorry. Yes, right.
Yeah,
right.
it
Sorry.
would be a decrease in
Right.
the rent.
Okay.
All right. Okay, anybody else?
But he gave two numbers. He gave 1,300.
Have your microphone.
Yeah, just speak into the microphone, Commissioner.
He
Thank you.
gave out two numbers. He gave 1,300. We got 10,000, and he says it can cost 60,000.
No,
I'm gonna go for 10,000. What happened if he changed his mind and he goes for the other numbers? You understand what I'm saying?
Well,
No, right. This is gonna.
No? We're gonna settle it now?
okay. Well, back to Eric's point, though, we're working without these things in evidence.
Yeah, that's
We have
what I'm
Tom,
saying.
Tom's testimony.
That's what I said, that he didn't submit those things. That's up to you as the board, whether you want to accept it, reject it. My suggestion was that, I thought the inspector's estimate was kind of low, and I was looking to split the difference between what the gentleman paid for it and what the inspector said. That's up to you gentlemen.
Yeah,
ladies.
that may be fair, but we have, I can't calculate that in my head, what the new rent will be or anything like that.
okay.
So, we're just working based on your testimony now, Tom.
So would it be in the best interest just to have them submit it over?
Resubmit?
And resubmit and start from there? Because
Okay.
right now, we don't have the new numbers that's going to be
Okay.
added to the situation.
Again,
Versus
that's-
if I do it right now, it's going to be totally different than what you're talking about.
Yeah, that's what
Okay.
I said.
Yeah, and-
He could change his mind.
Also, this
Sorry.
may not
Just,
need to
again,
come
I
back
just
to the
wanna
rent
check-
leveling board if it's accepted, right?
Right, if it's accepted, it wouldn't come back to rent leveling board.
Okay.
Yes, absolutely right.
Okay, so, yeah, I think it's kind of beyond our scope right now.
Right.
To try to make a calculation or decide if that's right. I mean, if he only has to submit back to the Bureau, then it'll probably be accepted based on your recommendation, and that'll be the end of it. We, hope.
Okay, so
Well, if
we would
that's
need a
gonna be the
motion.
case, why not
Motion
just do
to-
it now?
Motion to close.
Yes, I'm sorry. So, you would need a motion to close.
Motion to close.
And then a motion,
Adopt the hearing officers.
right. So you'd have to, so again, whoever wants to make the motion and then second it, so,
Motion to close is
okay, this is a
public
motion to
portion of the
close.
meeting.
Second,
Okay, and that is seconded by Commissioner Eacock.
Motion to it.
All in favor?
In favor?
All in
Aye.
favor?
Aye.
Aye.
Okay. And
Motion to adopt the hearing officer's opinion based on,
speak into the mic.
oh,
Yeah.
I'm sorry. Motion to adopt the hearing officer's position on the information that was presented to us that we don't have, that will be sent back to the office for approval.
Okay, so we have a motion from Board Chair to remand back to the Bureau. Do I have a second?
Second.
Okay, that was a quick second from Commissioner Hamilton. All in favor?
Aye.
aye.
Okay, unanimous.
Thank you.
All right, thank you.
Thanks.
So what does that mean?
When he can change his mind and bring it up
Oh,
higher.
now he's got to go back. He's got to go back
Yeah.
to the Bureau.
Yeah.
Bureau of Rent Leveling with the facts, and Tom's new estimate, what it should be, because we can't work with numbers in the air.
If he did the recalculation, I wouldn't have had a problem.
If he what?
Tom was gonna do the recalculation.
He was going to do it right here?
Well, no, it's
No, but he was going to do it right here?
I think Tom was going to, I think he wanted to try to.
Yeah, let them go back to the Bureau and do it right.
Because then, like you said, if they do it, we might not even
Yeah,
have
there's a
to.
lot of things in the air.
He might just go ahead and say, okay, no problem. We don't
Yeah,
gotta
let
come
them-
to-
We don't have these facts and evidence or anything
Right.
like that.
Agree.
Commissioners, are you ready for the next
Yes.
item on our agenda? Okay.
Okay. Legal rent petition, property at 506 Central Avenue. Landlord is TEJ EIP LLC. Vishnu Patel.
Good evening. Matthew Lammerts, I'm counsel for the owner of 506 508 Central Avenue LLC, Tej Dip LLC. This is our appeal that we brought of the determination of the rent leveling administrator, finding that the building is subject to the rent control ordinance of Jersey City. This is a new construction building. There's a state regime that provides for exemption from rent control for 30 years. And the purpose of that regime is to encourage construction, new construction, and to allow owners to finance that. In support of our appeal, we do have 3 witnesses that are intended to testify. There's really 2 issues that are before the board. New Jersey courts have found that not perfect compliance with the statute, which requires that a notice be sent to the tenants at the inception of the tenancy, and then also that a notice claiming the rent control exemption be sent to the building department of the local municipality. But it does require what's called substantial compliance. So the landlord's contending here that there was substantial compliance with those 2 applications, and I have Vineet Patel, a representative of the landlord, to testify both to his efforts to provide the notice of the rent control exemption to the building department of Jersey City, and as far as the notices that were provided to the tenants, which, as in our papers, were admittedly belated, but they were provided. There's no tenant at the building at this point in time that wasn't notified of the fact that the landlord intends to claim that new construction exemption from the ordinance. I also have Joseph Mazzone, who is the landlord's expediter, in connection with the building and permit applications, to testify as to the delivery of those documents to the building department, because there were some issues with submissions in an online portal. And then finally, Apurva Patel, who would also testify with his role in terms of the development of the property and communication with officials from Jersey City regarding the status of the property. So with that, I would like to call Vineet Patel as a witness. And I do have this prepared as like a direct examination. I don't know if
He's the attorney.
you want me to just share the microphone with the witness, or
This would be sworn in.
Of course.
State your name and spell it, please.
Vinit Patel, V-I-N-I-T. Last name Patel, P-A-T-E-L.
Okay.
You swear the testimony about to give in this proceeding is the truth, the whole truth, and nothing but the truth.
Yes.
There's another microphone right there.
thank you.
And I can hear you pretty well, as long as I'm able to make it.
Understood. I don't know if it's. Are we on? There we are. All right, Mr. Patel, what do you do for a living?
I own and operate a chain of supermarkets with my family and do a little bit of residential and commercial real estate management.
And can you describe for the board what experience you have in the development and renting of residential real estate?
This project was actually my first experience in development, but I've been renting some older inventory units for about 3 or 4 years prior.
And you're familiar with the property located at 506 Central Avenue, LLC?
Yes.
Or 506 Central Avenue in Jersey City?
Yes.
Are you affiliated with Tejdip, LLC?
Yes.
Is that the owner of that property?
Yes.
And what's your affiliation?
I was appointed by the ownership to oversee the development of the property from the old supermarket to what it stands currently.
When did Tejdip, LLC first become interested in developing that property?
2017 sometime.
And can you describe the steps that you took as far as retaining an attorney, an architect, et cetera?
Yeah, so we hired LLA architects Lee Levine and attorney Jim Burke, both out of Hoboken.
When you initially submitted your zoning and planning application, how many units were you seeking to build at that property?
20 units originally.
Do you know if there were any issues with respect to the height of the building in connection with the zoning application?
Yeah, so we were actually in a flow-through lot, the central side being an R1 and the Cambridge side being an R3. So because of the height variance of maximum of 3 levels on the R3, we had to go for variances. We met with the RNA and WPA neighborhood groups numerous times. Eventually, we came to a plan that appeased the whole community and were eventually granted permission for the 20 units by the planning board.
Did you have any conversations with anyone from the Jersey City Council regarding that expansion, the expansion of the number of units?
Yes, we had conversations with Councilman Yoon through David Diaz.
And what were the substance of those conversations?
Actually, when we demoed the building after the original 20-unit building had been approved, we came to the realization that the adjacent building, the bicycle shop on Central Avenue, was actually in terrible condition and was leaning on us for support for an unknown amount of years. So our original plans that were approved were actually scrapped for a limited amount of time until we figured out what we could do. The additional costs were just too great to continue with the current project. We met with Councilman Yoon, and he came up with a suggestion to add 5 more units, and they would support us fully if we were to make a couple of those units affordable.
And when you say affordable, what do you mean by that?
80% medium income housing affordable units. Out of the 25 units, we were required to deem 2 of them.
So there are 2 units in the property that are essentially restricted in rent to a certain amount based off of
Yes,
AMI?
correct.
Okay. And just to be clear, those additional units that you were granted, that was directly related to your agreement to have some affordable housing units at the property?
Yes, they actually said we will give you full support and make sure that this project gets approved if you guys agree to 2 affordable. That was their give and take. They said, hey, we don't want to see a hole in the ground for years to come until a developer takes this on. So we'll support you in that if you give us the 2.
At any point in time, did you have any reason to believe that anyone you were speaking with at the city would have had any reason to believe that you were building this as a rent-controlled property?
No, because no developer would agree to affordable housing if it was a rent-controlled property.
Did you have anyone working as an expediter in connection with the zoning and planning application?
Yes, Joseph Mazzone.
And can you describe his responsibilities and the services that he provided to Tejdip LLC?
Yeah, his tasks were, like his title says, is to expeditiously navigate the building, planning, zoning, as well as fire, water, and sewage departments, and take care of all the paperwork necessary in a timely manner.
During the development process, did you ever become aware of a requirement that you submit a rent control exemption letter to the city in order to claim the exemption?
Yes.
How did you become aware of that requirement?
Our attorney?
Do you know if a letter was ever submitted?
Yes.
So I'm showing Mr. Patel a document, and this is in the record as page 3 of Exhibit 3. Do you recognize that document, Mr. Patel?
Yes.
What is it exactly?
It's the rent control exemption letter that was submitted to the building department.
And who exactly drafted that letter?
I drafted it with the help of our attorney.
What steps did you initially take to submit that letter to the city?
So after it was done, I know our CO, we were actually expecting in about a month or a month and a half from this point. So I called them to see if I could come drop it off. At this point, I think there had been a COVID outbreak, so they were accepting no in-person submittals. They said the only way you could submit was through the online portal. I went ahead and submitted the document to my knowledge at that point successfully. A couple of days later, I think we confirmed with them, tried to confirm with them if they had gotten it. They said no, nothing had been submitted. We tried again on the portal, again, tried to confirm they had not gotten anything. So we were unsuccessful in submitting it that way. The next step was basically to give it to Joe to submit it.
When you say they, who are you communicating with?
The building department.
Just for clarification of the record, you said you submitted it to Joe.
Yeah, Joe Mazzone.
Joe, I'm sorry?
Joe Mazzone.
Joe Mazzone of,
Expediter.
okay, of the, this is a city agency?
Oh, no, Joe Mazzone, our expediter. He's also a witness today.
Oh, okay.
Yeah,
All right.
along with the series of other documents he was also delivering to the building department.
Okay, just so the record is clear, Joe Mazzone. Okay.
He's the expediter, he's not a city official. How did you provide a copy of the rent control exemption letter to Mr. Mazzone?
I believe it was in an envelope along with other documents. The ACM panel certifications, as well as the as-built survey for the final construction.
And did he describe to you his efforts to submit the documents to the city?
Yes, Mr. Joe had a meeting with the building department. It was a preset meeting, but I believe he hit some traffic on the way over. and there was a subcode official that was filling in for the original subcode official. And due to Mr. Joe being a few minutes late, I believe he would not see him. They got into some sort of argument, and Mr. Joe ended up leaving the building department without successfully delivering the letters.
Did he ever attempt to redeliver the letters?
Yes, I believe the next day or 2 days after, Mr. Joe was able to clarify it and was able to go and drop off the letters to the front desk of the building department.
And did Mr. Mazzone confirm that that envelope had been delivered?
Yes, he did.
What were the other documents that were contained in there?
It was the ACM panel certifications as well as the as-built survey.
Okay, and what was the date of that exemption letter?
February 1st, 2022.
Was that substantially around the time that Mr. Mazzone would have hand-delivered it to the city?
Yes.
And did Tejdip LLC eventually receive a certificate of occupancy for the property?
Yes, we did.
Which I'm now showing to Mr. Patel. This is page 66 of Exhibit 4. Is that a copy of the CO that was issued for the property?
Yes.
And do you know what the date of that CO was?
I believe it was May 4th, 2022.
So was that rent control exemption letter delivered to the city, to your knowledge, at least 30 days prior to the issuance of the certificate of occupancy?
Yes.
Okay. Can you describe how the owner was going to finance the construction of the property?
Through a construction loan with Spencer Savings Bank.
And when was that construction loan set to come due?
August 2022.
Did you need to do a refinance in order to pay off that loan?
Yes, we need to get into permanent financing.
Okay. And what did you need to do in order to refinance that loan?
I believe cover our debt service ratio as well as reach a 90% occupancy on the building.
Okay. Was there a point in time where there was a natural disaster that caused delays in financing and construction and leasing of the property?
Yes, I believe September of 2021, there was Hurricane Ida, which caused massive flooding in the heights. And we actually ended up with 6 feet of water in our underground garage, which completely submerged the electric panels. The Siemens rep ended up deeming it a life risk hazard and deemed them unusable. And basically all the electric panels, which were unused at this point, had to be replaced.
Was there an estimate of how long it would take to get the equipment necessary to do those repairs?
Yeah, it was 54 weeks for regular shipping and I believe 16 weeks for expedited if you paid double.
How did that affect the building and financing of the property?
I mean, it kind of left us at a standstill at 95% complete, and we have to wait for these panels to arrive. Once the panels arrived, we quickly finished the repairs and had a short window to get the building, 90+% leased at a lower than market rate, so then we can acquire, refinance into our permanent financing before the rates skyrocketed, which they were weekly at that point.
Excuse me, Counselor?
Yeah.
Can I just interrupt for 1 second?
Sure.
Roughly about how many more questions do you think you may have? Because
I would
just don't know if we're-
estimate that this witness would probably testify for another 5 to 10 minutes. I'm about halfway through.
Sorry? No, yeah, because I was just trying to find, is it really going to be absolutely relevant to what we're looking at? Because it looks like some of the points that are here, at least this is just my opinion,
Yes.
that the crux of it, we kind of understand. And I just don't know if we're going, this is kind of minutia that I don't really know is going to be relevant to, well, I won't say relevant, that's probably not the right word. But I think we understand the general concerns here, and I don't know if,
I can try and cut to the point. I mean, there's another issue here that's being raised, which is really that there are extremely high construction costs, and the landlord was in a position where, in order to make the project financially viable, they had to rent the building at below market rents. And that's due to the financing situation that they ran into. And that was done on reliance of the fact that they would be getting a 30-year exemption from the rent control ordinance.
Right, so all the information you have was already submitted to us, right?
Yeah, that's correct.
Right, so we kind of like got that part. We read everything that you have, so we're just trying to get to the point of what's the like the point, like where we going? Like if you're just gonna tell me that either he did do it or he didn't do it, like what happened?
How I'll put it this way then. When you, at the end of construction, do you know about how much TEJDIP LLC put in terms of its own capital and how much it borrowed to complete the construction of the building?
Yeah, about $3 million personal capital and $7 million loan.
And what are approximately the monthly costs that TEJDIP LLC has to both to service that loan and operate the building?
About $70,000 a month.
And how much, under the current rents that TEJDIP LLC is collecting from the tenants, how much revenue does that generate?
I am not exactly sure today's number, but we're running at a $250,000 annual deficit.
Understood.
Yep.
These efforts that TEJDIP LLC went through in terms of the financing that acquired on the property, was that done in reliance of the fact that there would be a rent control exemption?
Yep, that's why we filled it quickly at lower than market rates, because we had no intention of being rent controlled.
Now, with respect to the leases at the property, was there a property manager for the property?
At the time of the original leasing, yes, it was Liberty Realty.
And who drafted the initial leases to the tenants of the property?
I believe in conjunction with our lawyer and Liberty Realty.
Were you aware of any requirement to notify the tenants of a rent control exemption being claimed at the inception of the leases?
No.
Did you have any intent to deceive the tenants with respect to the rent control status of the building?
No.
Okay. And to just move this along, there was a point in time where you sought to increase the rent on the property, correct?
Uh-huh.
And did you receive any complaints to the rent control board after that occurred?
Yes, 6.
Okay. After that happened, did you provide notice to the tenants that you were in fact claiming a rent control exemption under the state statute?
Yes.
And how did you provide those notices to the tenants?
Through certified mail and online portal.
Have you provided notices regarding the rent control exemption to new tenants that signed leases at the
Yes.
property since the appeals were filed?
Yes.
And what essentially are the contents of those notices?
That we are currently rent controlled and that the landlord has filed an appeal to this rent control, and shall the appeal be granted, their rents may increase in excess of what the rent control statute states.
Is there any tenant currently residing at the property that hasn't received notice of either the claimed rent control exemption or the pending appeal?
No.
Approximately how many tenants are currently residing in the building that did not receive that initial exemption notification at the inception of their lease?
No, I'm not sure at the current, because we have some vacancies.
Is there anyone currently residing there that's not a process of this appeal that was one of those original tenants?
Yes, I believe so, at least 2 or 3.
Okay. How many units are in the building?
25.
Okay. Approximately, is it less than 10?
Yeah, it's less than 10.
So the majority of the building's been notified both of the pending appeal and of the claimed exemption?
Oh, no, everyone in the building currently, even the new leases have been, I've been told that we're in the appeal right now.
If I may, counsel, I think we're kind of prolonging this. The question is whether or not, the owner, this gentleman here, or an associate filed a request to be rent control exempt before the 30 days of receiving that CO. I believe he's answered that. Obviously, yeah, you're supposed to provide in the lease that this is a rent control. You have to notify the tenants. That's great. But the question really here is whether or not it's proven that it was done. And his testimony is that I gave it to Joe Manzone, correct? Joe Manzone dropped it off at the office of the construction code official, correct? Okay.
Well, there's 2 issues, because the rent leveling administrator also based the determination in part on the fact that these notices weren't provided to the tenant, or the tenants at the inception of the lease, and that's what we're getting at, right?
Okay,
So
but he's stating right now
No.
that he did, right?
what he's stating right now, we
Yes, we did,
concede.
Okay.
We concede that at the inception of the initial leases, because the landlord was working through a property manager and was unaware of the requirement that notice be provided, that there were tenants that were not provided within that lease the notice of the exemption from rent control. This goes to the issue of substantial compliance, like I said, which the New Jersey courts have said we don't need perfect compliance with the statute, we need substantial compliance. So what I'm trying to do is describe the situation that you have a rather inexperienced landlord. It's the first development of a multifamily building. He's relying on the state exemption. They've put substantial capital into the building, and through no intent to deceive the tenants, through an oversight, really, that initial notice wasn't provided. They did everything they could to submit the exemption letter to the city, and then as soon as they became aware of that requirement, they provided it. So now we have a situation where you probably have a handful of tenants, less than 10 out of the total amount that's being rented, that are those initial tenants that weren't provided with that notice. They've been provided that notice at this point. And overall, our point is that the landlord has really done everything that they could to substantially comply with the requirements of that statute, both by submitting that rent control exemption letter however they could to the building department, and as soon as they became aware of it, to provide notice to the tenants that they were claiming this exemption. And the notice even claims at this point in time that this is subject to an appeal, and the landlord is going to honor the result of that appeal.
And that's what the statute asks, is that prior 30 days prior to receiving the CO, you have to request, and you'll request a rent control exemption from the office of the construction code official, and then it'll be granted. Okay,
Correct.
that's what the statute states.
Correct.
Okay. I mean, that's really all I need to hear as to whether there's testimony. I mean, I leave it to the board, but I mean, really, it's just, did you or did you not drop it off? Also, do you have proofs? Do you have receipts from the office of the construction code official? Again, going into after the fact, after receiving the CO and, as much money as you put into, I don't know that that's relevant to what we're arguing here, which is whether the building is rent control exempt or not. And if you've go, I'm sorry, Commissioner.
Yeah, I actually did, and that's kind of what I was trying to get to, because Counselor, for the managers, I totally get the position that you're coming from. One of the things that I was going to, I just had a couple of questions.
Sure.
In reading some of the documentation, I understand a couple of tenants. The tenants in 102 and 302, they vacated their apartments, and I'm under the impression, I didn't see that the reason behind it, but it may have been because of the rent increases. Perhaps they couldn't afford it. Do you have any idea why they may have vacated?
I have a management company that's dealing with the tenants, so I'm
Okay,
not sure
well,
the
all
reason
right.
exactly, but I can find out.
Okay, it's not critical, but when I saw that there were some tenants that had left, I was just trying to connect some dots.
Well, as soon as we found the decision was made, the rents are back to what they were, and with a 4% increase.
Okay, it's just a concern. But when you were talking about, because one of the other things, I'm not a lawyer, obviously, but when I look at a matter of substantial compliance versus strict compliance, when I look at a tenant, I don't expect a tenant to understand rent control. I do expect the landlord or a property manager to understand the guidelines that the city is asking them to abide by as far as any of these regulations are concerned. And I do expect them to be handled
Trustworthy,
strictly,
right.
because it's in black and white. And that's one of the responsibilities, I think, attached to landlords, as well as property managers. That's the tough part for me. The other is the strict compliance, the substantial compliance thing. I did not see that in any of the documentation that was submitted to me. So I guess I can go back and look for that. But when you were quoting that particular, explaining that particular statute, I just didn't see it in any of the documentation that was submitted. Unless it's something that I just...
Well, I'm not sure what's missing. Part of what was submitted was the notice of the exemption. So there's two issues, right? There's the notice of exemption that's
Right.
to the building department. We have an issue of delivery there. The building department contends they didn't receive it. We have no method of receipt because the landlord submitted it online, didn't receive a receipt. I can have Mr. Mazzone testify as to his delivery of that envelope. He didn't receive a receipt for that envelope. So frankly, we... Mr. Mazzone would have to testify to that.
It's not the. It wasn't. It was. We going back and forth. If it wasn't submitted to the department, we don't have it. We can't say that it was or it wasn't. He can testify that he gave it, but it's not showing up to us saying that it was given. I would like to hear from the tenants, to hear their side, because we're going to be all night talking about if we did or we didn't. I just want to hear what they have to say, and then we move forward with our decision on whether or whatever we should do about this.
Okay.
All right.
I would say, I understand and respect that. Our position essentially is this is a question of hardship and prejudice, right? We recognize the fact that there were tenants that didn't receive notice of that. And I believe I put in my papers that the landlord's prepared to honor that they're not going to escalate for those tenants that are residing in the property, that they would get increases beyond what's in the rent control ordinance. But this is really an exemption that's extremely valuable to the landlord and necessary in order to recoup their costs. So it's an undue hardship on the landlord essentially to require that the entire building be subject to rent control on the basis that some tenants weren't notified. And we would be prepared to honor that with respect to those tenants and understand that they may have entered into the lease under the understanding that that ordinance might apply to them. But for every
Counselor-
other tenant that's been provided that notification, we would ask that the board consider the building to be
But
exempt.
Counselor, you do understand because of the ordinance, you still, the 30 days, we have to follow that also.
No, I understand that. I
Okay.
understand that. Our
All right.
position is it
All
was
right.
submitted.
Okay.
I understand that that's a proof issue for the board to determine.
Right.
So is it possible that 15, I hear the numbers 15 and 10, can 15 be exempt from rent control and then the other 10 remain?
I'm sorry,
under
just
rent?
commissioners, just make sure that your microphones are on. The green light is on,
Yeah, it's on.
so that we have
Hello?
it for the record. Yeah. Okay.
Okay.
Thank you.
So, yeah, what I'm not sure, I mean,
The
I'm
building's
sorry,
either-
it sounds like there's a hybrid situation developing where you have 15 exempt from rent control and 10 will remain under rent control, I guess, until those tenants vacate?
The building is either exempt or not exempt. I'm
Yeah, yeah,
proposing
that's
an
what I
equitable
thought.
solution to the board to find that the building is exempt from rent control, but that the landlord, that be on the condition that the landlord honor the annual rent increases that are set by the ordinance with respect to those tenants that did not receive notice at the inception of the tenancy.
Oh, I guess, our question would be, is this hybrid situation allowable? Is it either it's rent controlled or not? Yeah. I think that's
So it has to be
unfortunate
all or
problem.
one? It has to be all or none. Is that it?
Okay, do I need swearing, don't I? Okay. Hello. I do. For the record, my name is Chiron Richardson. I am the rent level administrator. So yeah, the answer is no. It's you cannot have a hybrid situation.
Right. Okay.
And that's through the chair. That was my main concern was I don't think we have the power to authorize what you're offering. It just, that goes against the city ordinance, so we don't have control to do that.
Exactly.
With that, if you'd like to hear from the
Here's
tenants.
the
that's our
tenants. Thank you.
It's a bitter pill.
Commissioners, I just want to make a clarification. It's not necessary, we're not talking about the ordinance, we're talking about a state statute. Okay.
Bradley Parrott, Bradley, Parrott, Parrott. Yes, I do. Hello, ladies and gentlemen of the board. First off, sorry for my nerves. I'm not used to speaking in front of a microphone here. As I just said, my name is Brad Parrott. First off, I'd like to thank you for your thorough and diligent review of the case, and for putting up with probably many of my personal attempts to be in touch to learn the status of our petition. I'm a pretty normal guy, commuted here from the city today, like hundreds of thousands do every day. I earn a modest living. I don't spend beyond my means. I live where I can and live life well. But, this entire process has admittedly been a significant drain on myself and the other tenants of the building. In the first year of living in this building, there were many instances that would result in anyone wanting to move out, frankly. Poor security, break-ins, thievery, issues in the units relating to, some of the air conditioning, some of the appliances. A lot of this was not addressed quickly, and a lot of it was met with, frustration on our end. There was lack of preparation and empathy, and that's from the landlord, and that's kind of a common theme in this case. After the first year,
it was really disappointing and frustrating, frankly, to get a 25% increase on my rent. Every attempt to negotiate with the landlord was swiftly rejected. I was disappointed because I considered myself to be a good tenant. I always pay on time. I assisted with issues around the building, picked up trash in the hallways, cleaned up animal excretions that were in the elevator, dealt with police during those issues that I mentioned earlier, where we would have thieves come in and break-ins and things like that. So, I, along with many others, we were trapped with the decision of, do we go through the process of finding a new home, paying a finder's fee, moving everything, and kind of, starting that process over again? Or do we just deal with the increase? 25% increase on anything is substantial year over year. Many people did opt to move out, others stuck around, and then eventually, a group of us decided that we should submit a petition. Because we felt that these were predatory practices, and also we were never notified that the building was exempt from rent control. I clearly don't have a law background. I'm a sales guy, but I reviewed all of the exhibits within the that were submitted to us, and I think it's fairly clear, in your determination in Exhibit 4, pages 1 through 9. What the requirements are to be exempt from rent control. And in each instance, it seemed that the landlord attempted to share proof that he satisfied these requirements that the board refuted. The practices of the landlord are alarming, considering, like he mentioned earlier, this was his first residential property. In the first opportunity that he had to increase tenants' rates, he did it by 25% and immediately rejected any attempts to negotiate. It was alarming that he had such little regard for the inhabitants of his building, and was seemingly eager to try to force people out or force people into a decision of moving out or accepting this significant increase for their living situation. So that's all I really wanted to say. We were all put in a really difficult position, and that's why we did ultimately file this petition, because we felt that this was not right, and we did find that he was not satisfying all of the requirements as clearly stated by the Rent Leveling Board. So thank you for the time, and appreciate all of your efforts again.
Does the commissioners, do you have any questions?
Anybody have any questions for the tenant?
Or do you have any questions? Okay. I just want to say one thing too. Those tenants that are here, you're here for an illegal rent increase. I understand that there may be terrible conditions or maybe a failure to maintain services, but tonight we're here to discuss the illegal rent increase, also whether this property is rent control exempt or not. So again, we just ask if you just stick to those points on the record. That's pretty much it. If you want to call the next tenant.
Any other tenant?
Daniel Devine. Yeah, it is. I do.
I'm sorry, Mr. Devine?
Yes.
Yeah, just if you could step up a little bit closer, and it's Devine.
That's right.
Okay, thank you.
Again, I just want to say thank you for the time and reviewing our case and everything. Just the one thing I wanted to add is, in light of the 25% increase, we were given a 10-day notice to make the decision, which I know it is a law to have at least 30 days in Jersey. So I think that's really what stuck me the most, on top of, a 25 and really an unreasonable increase, and then 10 days to make that decision to the landlord, which I think we really put us in a tough decision where we had to, again, file this petition.
Is there, excuse me, is there a difference between your apartment and his apartment?
No, we're all, I'm in unit 406. We all just joined together.
One bedroom, 2 bedrooms, they're all one?
I'm a 1 bedroom. I think Brad is in a studio, and
we can't.
Yeah, we can't take testimony from when they come up. They can answer any questions,
Okay.
but right now we want to focus on Mr. Devine. Yes. Okay, so You're
He was-
dismissing Mr. Devine?
Yeah, no, he
You're
was.
finished?
I'm
That's all I
finished
really
with
wanted to say.
That's all. You said you was in a
It was a 10-day notice to make the decision to the
right,
landlord.
but one bedroom. You said
I'm in a
you were?
one-bedroom, yes, sir.
All right, and Mr.
Yes.
25.
Yes,
and
sir.
Mr. Parrott, you're in a.
Sworn again, or
No.
I was in a studio, or still am in a studio.
Studio, and you're paying 25% increase also. Or it's a-
After the decisions were made, I came back to the landlord and the property manager and negotiated adjusted rates, which resulted in me getting a credit because they agreed to the rates that would have been accurate for the CPI percentage increase year over year. That was I can't give you exact dates, but that was more than a year after paying the 25% increase.
Okay.
Hold on. So you did pay the increase for a full year on the 25%. And did you also receive notice with only 10 days notice?
I can't remember the exact amount of days that I received notice, but it was a short amount of time.
Okay.
And I think I don't have the actual lease in front of me at the exact moment, but I'm not going to go any further. It's in the exhibit, but the wording on the amount of time that the landlord needs to give a notice of an increase and the amount of time that the tenant has to respond was seemingly different from what a typical lease would state.
And for the record, I just want to ask, what is the legal
Noticing?
time on that?
So state law requires landlords to notice their tenants 30 days in advance. In the ordinance, you whatever month that falls on, you have to use the CPI increase that is provided by the Bureau of Labor Statistics, and if that exceeds 4%, you cannot increase the rent more than 4%.
Right.
So whatever the monthly CPI increase is, that has to be applied. It will never be 25%. 25% is used by those landlords who believe that they are rent control exempt or are rent control exempt. In this case, can't do that.
Right. Anybody got anything?
As a matter of fact, and even taking a look at the CPI for, I think, last year, it was pretty doggone low. It was something like 0.04. So it's not like it's a significant number there.
Any more questions, commissioners? No more questions? Okay. Motion to close.
Oh, I mean,
Oh.
we
Oh, you got-
have.
I was going
we
to
have-
state,
Yeah, we have
I'm sorry.
tenants and we have rebuttal, and we also have a hearing officer here for questioning. If you.
I was just going to state there was an agreed upon 4% increase for my initial renewal that was adjusted from the 25% increase that I was paying for a full year. And then we agreed to a 2.9% increase in, that would have been May of this year. So if it was 0.5%, then it's not what my increase ultimately ended up being. What we agreed upon between the landlord and myself.
Okay. Okay. Counselor?
The only thing that I would add would be with respect to the notice period that the tenants are describing. The landlord sent out renewal notices, my understanding is, to all of the units at the same time in substantially the same form. It's attached as Exhibit 1C, page 1. And notice was given on March 29th, 2023 for an increase to go into effect on May the 1st. Or, I'm sorry. May the 1st of that same year. So I believe the 30-day notice was provided by our client, and that's in the record as far as when they actually sent the notice. That was the only discrepancy that I believe that I had with the documents that were on the record from what was said here.
All right, can we hear from the hearing officer? No, that's it. All tenants is done. Okay.
Good evening, everyone.
Good evening.
Okay. So again, I just want to state that the Bureau is absolutely understanding and sympathetic in terms of the money that went into this property. But because there's a few things, it's new construction. which means that if anybody's going to put that much money in, you should definitely do your due diligence to make sure that you put in all the paperwork to make sure that it's rent controlled. The attorney has already proven that both the letter was not submitted 30 days prior, and then the furnishing to the tenants of notice was not submitted. And so based on those two alone, the ordinance says that this property is not, it is subject to rent control.
Yes.
So I just want to say that, we are sympathetic, but the fact that this is a new property, this is not like the Portside situation when you had 30 years prior. And with those things happening, you would be even more due diligent to make sure that you get the paperwork in the proper time. So if we're going to stick to the ordinance and just stay uniform based on what we've done in the past, I believe the evidence proves that they have not done their due diligence. And unfortunately, we realize that it's a lot of money, but if it is that much money, you better believe that I'm not going to stop it from just not submitting 2 letters. Something as simple as 2 letters can cost you millions of dollars. I'm not going to lose those millions of dollars for not submitting just 2 simple letters. And so, and as you see, even in the evidence, the Bureau did its due diligence. We didn't just make a decision offhand. We reached out, we went back and forth. So we really did try to do all we can to make sure that we could show that we did not find any evidence that they did what they were supposed to do. So I just want to put that on the record.
Okay. Thank you.
Thank
Any
you.
questions?
Okay. Tell them to let the attorney rebut.
Motion to close?
Okay, I have a motion to close by the board chair. Do I have a second?
Does the attorney have anything to say?
Wait, hold on.
The attorney, does the attorney have any rebuttal?
He did already.
Oh, okay.
Okay, second made by Second made by Commissioner Brown. All in favor to close the meeting to the public?
Aye.
Okay, unanimous.
Okay. All right.
I don't think we have any choice.
Yeah.
We have to make a motion. Uphold.
Again, please
Motion-
just remember to speak into the microphones.
Motion to adopt the hearing officer's decision.
I make a motion. Oh,
Go.
okay.
Go, you go ahead.
Yeah, I make a motion that the board favor what the rent control department has done in terms that the landlord has failed to provide the sufficient proof of compliance with state law NJ SA 24:42-44, and therefore the Bureau finds that the property is subject to rent control.
All right.
So there is a motion to
Motion to adopt.
to accept, yeah,
To accept the hearing officer's
to affirm
decision.
Right. The
hearing officer's determination.
Yes.
yes.
Okay, do I have a second?
Second.
Okay, second was from, sorry?
Elder Pensioner.
Elda, okay. Commissioner Pinchinat, okay. All in favor of,
Aye.
Aye.
okay, unanimous? No, that's, I'm sorry, I missed it.
It's closed. It's closed.
It's closed to the
Closed.
public, sorry. Okay. So motion passes to accept the hearing officer's determination.
He was, wait.
Unanimous.
Yeah. I feel bad for him. But
Okay, is there any other cases?
That is it. There isn't anything else on the agenda tonight. Do I have a motion to?
Motion to close.
Okay, so
All
a
in
motion to
favor?
close. All in favor?
All in favor?
Aye. Okay.
Thank you.
Thank you.
Thank you, everyone, for coming tonight.
Nice. That was a tough one, but
Yeah?
our hands were tied.
That was tough. Oh,
Our hands are tied. What are you gonna do? It's a state law.
well, I think it also opens the door when you start giving liens attached to one. It's like,
Oh,
it
yeah,
opens the
yeah.
door to having to do that in the future.
All we can do is follow the law.
Yes. That's right. That's what the court system is for.
Yeah, and he needed,
Have a problem making.
for him to overcome this final determination, he needed the proof.